Oh, sorry. Did everyone get the code?
Code. Oh,
Okay.
sorry, guys.
I didn't. I'll pause, I'll pause
Pause
for a minute.
there. Take a photo.
All right. Is everyone almost good to go? Thumbs up?
Yeah.
Yeah. Okay. Perfect. Okay, so I'll skip over this slide, but basically a little bit about me is that I'm an estate planning lawyer at Bell Alliance. So I am purely a solicitor. I don't do anything contentious. And I deal with everything from sort of wills, estates, powers of attorney, representation agreements, and also estate and trust administration. So the agenda for today, I apologize in advance. I've put a lot of information and words on the slides. But that's really because I wanted to just make sure that you have a resource to go back to in the future. So if needed. So we'll talk about sort of what an executor, trustee, and attorney is and why they're important. Also the important qualities and considerations that you should bear in mind or your client should be bearing in mind when they make these appointments. As Felicia alluded to, what can go wrong when there are foreign appointments. And we'll cover actually what the definition of foreign is and why that's important. And then just briefly at the end, if we have time, we're going to pack a lot into the next hour or so. But if we'll just briefly go through the different appointments, so sole, alternate, and also together versus together and separately. Okay, so executors. Hopefully, most of you are aware that this is the person. But it also refers to a corporate. And when we're talking about corporates, it's really a trust company or a law firm or other professional who's taking on that responsibility. And they are the person responsible for administering a deceased estate under the will. So the governing document is the will, and that is the document that should be checked to see the person who's providing the instructions or acting is actually the person who has authority. We'll come back to the legal authority in a little bit, but it's important to remember that a will only takes effect when somebody dies. So I often get calls from usually a child to say, I need to speak to you about my parents' will. And my first comment is usually, I'm so sorry that they passed away. When did they die? And they say, oh, no, they haven't actually died yet. I just want to find out information or change this or that. I am the executor. And I politely have to tell them that they have no authority to have the conversation with me. It's actually their parents' document until they passed away. That's when it crystallizes. Also, it can crystallize on an incapacity as well. So there's different sort of scenarios. So who to appoint? We'll definitely come back to this, but family, friends, other professionals, trust companies, everyone is a good option, but it really depends on the situation. There's pros and cons to weigh for all of these situations. But one practical tip is to make sure you ask or your clients ask before making the appointment. Unfortunately, I've had many situations, but one in particular where it took months and months to get an estate plan together. A lady who was lovely and said, yeah, no problem. My best friend will do it. We did the estate plan. A couple of weeks later, she came back and said, oh, actually, the person that she wanted to appoint didn't actually want to act in any capacity. So it was additional cost and time, which obviously I don't mind, but it was just an unfortunate situation where we had to go change everything. One thing I wanted to differentiate is administrator. So executors and administrators are often used interchangeably. An administrator is really where there is no person available in the will to act, or if there is no will. So it's essentially a government, the government dictates in the statute a priority of waterfall to who is able to act and take on that role. So generally speaking, it starts with a spouse. If the spouse doesn't want to act for any reason, they can nominate someone. If there is no spouse, for example, it drops down to the children. But in order for a child to act, they have to have the majority of the other children. So you can see it can get quite complicated. So it's always advisable to have a will and to appoint an executor. And just briefly touching on the sort of legal authority to act, the executor's will does stem from the will itself. The executor's power stem from the will itself. So that's often why executors can sometimes, not always, be able to do certain actions before the grant of probate is issued. And the grant of probate is essentially it's quite an actually underwhelming document produced by the court, providing that authority. The administrator, for example, where there is no will, they don't have any documentation beforehand. So it really is that estate grant that gives them the legal authority to act. Just for your reference, in British Columbia, the executors are governed by WESA, which is the Wills, Estates and Succession Act. And there's also some guidance in the Trustee Act. And hopefully it goes without saying that the executor must always act in the best interests of the estate and the beneficiaries. But unsurprisingly, conflicts most definitely arise, and especially when there is one individual, for example, taking on two roles. So if you have a child who is the executor, but also one of the many beneficiaries, for example, there could be competing interests on when they should or how they should be acting and when they should distribute. So I had one instance where there was a child. He was appointed as the sole executor, and he was one of three beneficiaries with his other siblings. He didn't get along with his other two siblings, and he actually, for reasons not properly documented, but it was surmised that he was sort of there at the end of his parents' life and was taking care of the parent who passed away, got the lion's share of the estate. He was also, it came about heavily in debt. And so he really needed those funds to come from the estate and be paid out to him. Now, you may or may not be aware that in BC, there's a 210-day waiting period after the grant has been issued, where technically and legally, you're not supposed to give out or distribute any estate funds unless you have consent of all of the adult beneficiaries generally. Obviously, his sisters were not willing to consent to that. So there was a pretty big conflict that ensued, and luckily I could pass it off to someone who deals with that, and it was not me. Okay, so just briefly, the executors are responsible for a whole host of tasks. So I've just put up on the slides a very small, a small sample. So the first thing, funeral arrangements and registering the death, usually that's done by a family member, but if there is no one to do that, or it could be the same person, then that falls to the executor. Searching for the will. So this probably seems quite straightforward, but it's actually can be a little bit more complicated. So I actually have a case going through the probate courts at the moment. I don't know what the result is, but I'll just set out the background a little bit. So we have an estate where they searched through the deceased's apartment. They did find a paper will in her files or her paperwork. They started the process with another lawyer to obtain probate. And a few weeks later, they actually found, they got onto her computer and they found a subsequent will that had been drafted a few years after the paper version. There were deficiencies with both wills, but we're essentially arguing now that the later will found in the computer should be the last intention of the person who died. So it's usually straightforward, but there can be some interesting twists and turns along the way. One of the main roles of the executor is to identify all of the assets and liabilities of the deceased at the date of death. So it doesn't matter what they had before, it doesn't matter what's in their account or what the value of something is a week later. It really is the date of death balances that we're concerned with, because those are the amounts that need to be disclosed to the court. So it's the executor's role to identify these and also liaise with those asset holders or creditors in relation to those, and also notify them of the death. One really important role that people don't realize is that the executor actually is responsible for protecting all of the assets. So they have to, if there's real property, for example, they sometimes have to change the locks or make sure that it has the proper insurance in place. Making sure that investments, for example, if something's going to mature, like they have to deal with all of that. So it's a pretty time-consuming task. Applying for the state grant is essentially the court process, and usually a lawyer would assist with that. And then the general sort of payments of the liabilities, making distributions to the beneficiaries, and obviously there's sort of nuances with all of that. Accounting to the beneficiaries. So although we always recommend that an accountant's on board to help with the sort of terminal and estate tax returns, they do have a duty to account to the beneficiaries, even if they are one of them. So how strict the accounting needs to be really depends on sort of the values, who the beneficiaries are. So the sort of belt and braces approach is to go through the courts and get the accounts approved. But oftentimes in family circumstances, that's not necessary. Okay. So we'll just move on to trusteeships. So hopefully the executor sort of role is clear, but it'll start to get a little bit muddied, I think, as we go through. So trustees. So these are the individuals, much like the executors or the corporates, who hold and administer assets on behalf of and for the benefit of a third party. So unlike the executor, where their governing document is the will, this particular role must look to the trustee. So there are different types of trust. So there are lifetime or inter vivos trusts, which one would look to. Otherwise, there are the testamentary trusts, which therefore the trust terms would be in the will. So that's the only instance where the will would be the trust deed itself. And there are sometimes subsequent documents, so a deed of appointment of successor trustee or a deed of appointment of additional trustee that may provide some guidance as to who the trustee is. So again, family, friends, professionals, trust companies, they are all very good options for different reasons, and we'll go through all of that. Just trying to really repeat, it's a message you'll see throughout, is to ask before appointing. Otherwise, it can cause some pretty big headaches in the future. I recently provided some advice to a trustee who was asked by a friend, I think it was a business associate, many years prior to this person passing away, to be a successor trustee in his family trust. And he was friends with the individual who passed away, but didn't really know the family or the family situation, but said, hey, yeah, I'll do you a favor, no problem, just name me. The individual he was friendly with passed away. The wife was actually the first in line, or the first alternate. She's unfortunately incapacitated. So now this poor guy has this massive responsibility as the trustee of a quite significant family trust. And so the discussion I had with him was whether he should take on the trusteeship or if he should pass it to someone else. One thing I just wanted to address is that the term executor is often used interchangeably with the term trustee. So this specific context is in the context of a will. So oftentimes when we draft, obviously there's a discussion with the client, but the executor is also the trustee. So that's why we sort of use the terminology synonymously. But they are two very distinct roles. So it is entirely possible to name an executor and then a separate trustee in the will. So it's just important to be mindful of that. Just because you see executor listed at the top of the document doesn't necessarily mean that they're the trustee for the testamentary trusts, probably closer to the middle or end of the document. For your reference, in BC, the trustees are governed by the Trustee Act. And just like with the executorship, the trustee must always act in the best interest of the trust and the beneficiaries. And again, conflicts can arise when you have the same person who's appointed under both roles. This often arises in situations where there's a blended family. There could be a spousal trust in the will, and the surviving spouse is potentially the trustee of their own spousal trust. And just by way of background, so spousal trust entitles the spouse to claim, or they are entitled to claim all of the income but also capital if there's provision in the will. So when there is that provision to encroach on the capital, obviously the residuary beneficiaries, who are usually children from a first marriage, might take issue with some of the capital encroachment going on. And here are just a few of the examples of what the trustee role entails. So it could be registering the trust at financial institutions or the land title office. And that's really to facilitate the changing of legal title. Not always advisable in certain circumstances, but that may need to occur. Protecting the trust asset. So again, that could be sort of, if there's real property, making sure that it's secure, it's insured. Also making all of the calls on the investments and making sure that they are acting for the best interests of the beneficiaries. They should be making distributions to the beneficiaries in accordance with the trust deed. And even if it's a discretionary trust, they do have a duty to consider making distributions, even if they don't end up making the distributions. So everything will need to be recorded. They're often involved in the appointment or removal of trustees. Like the executors, they have to account to the beneficiaries, and with the trusts, this is sort of on an annual basis. And they also have to file the returns and deal with the accountant in relation to the tax aspects. Okay, so attorneys. I often get a question about what is the difference between my executor and my attorney. Also, when I speak to US clients, they think attorney is a lawyer, which is always a conversation to be had, but once we have it, it becomes much clearer. So this is actually the person who's authorized to act on someone else's behalf. So the person who gives the power is called the donor. And the power of attorney in BC authorizes someone to act in relation to property, finances, and legal affairs. The only sort of general exclusions is that the attorney cannot make a will for someone. And I've had that a few times. Someone will call up and say, I'm their attorney, can I change their will? No, you can't. And also, I just wanted to differentiate a little bit between Section 7 and Section 9. So for this presentation, when I say, or when I detail power of attorney, I'm really talking about a Section 9 power of attorney under the Representation Agreement Act. And that's really when someone has full capacity, they understand the power they're giving away, their assets, their relationships. So the threshold is considerably higher than for a Section 7 representation agreement. And that's if there's diminished capacity. So there is a diminished, a lower threshold, but there's also a limit on what can be done in relation to a person's property, financial and legal affairs. One question we do get, and so I should have mentioned this before, is the attorney can't make a will, and they also generally can't change beneficiary designations. That comes up a lot. So unless someone wants to go to court and there's a really valid reason to do that, generally speaking, once capacity is lost, the beneficiary designations are locked in, because that's sort of like a pseudo distribution from the person's estate. One other sort of main point of confusion is that the power of attorney is only valid when somebody's alive. So as soon as they die, it ceases. There's no more possibility of using it. And that's really when the will kicks in. So even though it only applies when someone's alive, it's important to remember that there are two sort of general types of powers of attorney. An enduring power of attorney, which is pretty much live when the donor signs it. And then if capacity is ever lost, then it will continue. It is really flexible to have the enduring power of attorney. Obviously, there's the possibility of sort of an attorney acting as they shouldn't and doing things during the donor's lifetime while they have capacity that they shouldn't be doing. And the other general type is a springing power of attorney. So that comes into play on generally on a triggering event, which is an incapacity. So that would require, for example, a doctor's note or a statutory declaration to say that the person has lost capacity, which is why they're acting. So if you have a document, a power of attorney document in front of you, it's really important to check actually when it comes into play. Because if it's a springing power of attorney and you don't have the relevant information to point to the triggering event having occurred, then it's actually not applicable at that time. So again, family, friends, professionals, trust companies are all good options. And we'll talk about that in a little bit. Again, always ask before appointing anyone. And in BC, just for your reference, it's the Power of Attorney Act that we normally turn to. Just like with the other appointments, the attorney must always act in the best interest of the donor. But the Power of Attorney document itself can be sort of tweaked. So oftentimes we expand on what's in the statute and allow for the attorney to have much broader powers than what is prescribed. So it's always important to just double check the actual power of attorney to make sure that the attorney has the authority to make those, give those instructions or take those actions. And otherwise the Power of Attorney Act will sort of dictate that. So here are just a few examples of what an attorney might be required to do. So before they can use it, they'll have to register it with the financial institutions or the LTO, for example. Usually the financial institutions have their own sort of internal processes and policies. So just because someone takes it into the branch, for example, doesn't mean they can use it that day. There's often sort of a few hoops that need to be jumped through. Make gifts or loans to family members. And I just put that up there because that is one of the things that comes up a lot. And I know it's been touched upon on some of the previous presentations, but under the Power of Attorney Act, if the power of attorney does not expand this power, then the attorney is only able to gift the prescribed amount. So that's 10% of the donor's taxable income from the previous year, or $5,000, whichever is less. So for a lot of our clients, it's the $5,000 that we're looking at, which may or probably is not the figure that they had in mind. So it's important to expand upon it if need be. They can sell real property. And again, an expanded power that we usually include in our powers of attorney, for example, is that the attorney can benefit themselves. Because if that's not in there, then the attorney can only do transactions with sort of third parties. They cannot benefit themselves. So often if there's a couple, for example, we will make sure that they'll be able to sort of freely move assets between the two of them if that's what they want. The attorney will pay liabilities, also work with a representative. So the representative is sort of the equivalent for the power of attorney, but for health and care decisions. So as an example, if someone were to be moving into a care facility, the representative would make that decision, and then they would need to liaise with the attorney under the power of attorney to facilitate payments. And then obviously the attorney is responsible for filing the personal tax returns and arranging payment of anything owing. All right, so I know that was sort of a whirlwind in the different types of appointments. But hopefully you'll appreciate that they are three distinct roles, although sometimes there is a bit of overlap. But one really important thing that they all have in common is that a fiduciary relationship has been established. So that is when, and the key word is trust. So there's a special relationship of trust that has been established where there's one person acting for the benefit of another person. And carefully and prudently are usually the sort of terms that are thrown around. But yeah, there's a special relationship of trust that has been established in all three instances. Okay, moving swiftly along. So now that we know the different types of appointments, we'll just have a quick look at the ideal qualities and some considerations for choosing those individuals. So all three of the appointments are very time consuming. So I put up on the slides for the estate administration side. So for the executorship, generally speaking, for a really simple estate, it takes sort of 1 to 2 years. And that usually blows people away because there is a lot to do from the time somebody passes away up to sort of the final tax return and clearance certificate. So you want to pick someone who has time to deal with this. That being said, that looks pretty good because trusteeships and attorneyships can be much, much longer. So if, for example, there's a minor trust created in a will, say there's an unfortunate situation and perhaps a 2-year-old child inherits, in BC, the legal age is 19 when they get that, when they can have a right to the trust assets, but oftentimes that's pushed up to 21, 25, even 30 sometimes. So you could be looking at sort of 15, 20, 25 years of a trust being in place. Obviously taking into consideration other sort of tax rules, but it could theoretically go on for that long. And the same with attorneyships. So there's no real expiry on the attorneyships except death. So if somebody, for example, has early onset dementia in their 40s, but they live until they're 90, you can see there's a considerable amount of time that the attorney would need to be acting. Generally speaking, we recommend that the appointments are the same age as the person making the appointment or younger, because in the normal course of events, older people should die first. And also they should be relatively healthy. So those are a couple of considerations, and that sort of plays into one of the other considerations is that how likely is it that the person you appoint will need to resign or renounce? So we'll get to that in a minute. There's a lot going on. So the person you name should be organized, detail orientated. They should follow up. It's a full-time job in and of itself. So it helps if you have someone who's organized. They should be patient, decisive. Making decisions is a key part of this role. So they should be able to make decisions, obviously by consulting with professionals or others, but at the end of the day, it comes down to them, which is why you also want them to have some good judgment, and they need to have the ability to work well with others. So I've spoken previously about how, for example, an attorney might need to work with a representative, but there's also lawyers, accountants, financial advisors, insurance brokers. There's a whole host of individuals, the family members that these people will need to work with. So it's a good idea to pick someone who doesn't rub people necessarily the wrong way. They should be trustworthy. Hopefully that goes without saying. But whenever someone or a client is hesitant about appointing someone, we usually have a discussion about what the hesitancy is. And sometimes the answer is just don't appoint them. Financial stability. This is an interesting one. And it generally is applicable in an estate situation. And I actually I was on a Zoom call with an executor yesterday, and essentially it boils down to the executor having to foot a lot of the liabilities before the estate grant is issued. So this particular individual said that he had used his own about $14,000 of his own funds before the estate grant was issued. So granted, he will get that back from the estate, but what happens if the executor doesn't have that sort of money to sort of put towards the estate administration? So things can get a little bit difficult. Sometimes we have to look at sort of bridging loans from the bank or other sources. So it is not the only consideration, but it's definitely one consideration to be had. Do they want to act? So this sort of goes back to what I've been repeating throughout the presentation, but really and truly, it's important to ask those individuals before you actually appoint them. Where is the individual located? So we'll get onto this when we talk about foreign appointments in a minute, but that is one of the really big key considerations. Does the individual have any special experience or qualities? So if there's a business, perhaps picking someone who has some business acumen would be good. Is there a big investment portfolio? Perhaps someone who understands the markets would be a good choice. So I won't go through all of them, but it's definitely worth considering what the family situation is, what the assets are, and whether who you're appointing would be a good fit or not. What is the complexity of the assets, and are there sort of complicated structures in place? And if so, you might want to pick someone who has some knowledge or some professional experience in those areas. Otherwise, it can be extremely overwhelming for the individual being appointed. We've talked a little bit about conflicts. So just being mindful of the different hats and sort of what the different roles will entail is important. We also touched briefly upon the likelihood of the individual renouncing or having to resign. And that will usually be due to health or age or location. So we often have clients, or I have conversations with clients, and they'll say, well, I need to appoint this person, otherwise they're going to be really annoyed with me. Or I need to do this because so-and-so will say this. And at the end of the day, this is a really important appointment. So these considerations shouldn't factor into that. Does the individual have time for the administrative burden? We talked about sort of the timescales previously, so that's important to bear in mind. And what's the individual's risk tolerance? So executors and trustees and attorneys, because of that special fiduciary relationship that's been created, they can be personally liable in certain circumstances. So for example, in an estate situation, if they pay out to a beneficiary, but a creditor comes forward and they haven't waited the 210 days or had the consent of the beneficiaries or had the clearance certificate, they could be personally liable for those amounts. Should the executor or trustee be compensated? So this is a conversation I have a lot with my clients. Sometimes clients just want to appoint people who won't ask for money, which I do understand to an extent, but it is a big role and big responsibility. So just for your reference, an executor is entitled in BC to claim up to 5% of the gross value of the assets passing through the will. Generally, they can't just take it. It needs to be approved either by all of the adult beneficiaries or through the courts. A trustee is entitled, it's a care and management fee up to 0.4% of the value of the asset they're managing on an annual basis. These can be varied in the will or the trust document, but this is just what the legislation says. Generally, attorneys are not allowed to claim compensation unless provided for in the power of attorney. All three appointments can claim back reasonable expenses, but it is really important to sort of just think about if you do want to compensate individuals, what you think is fair based on the circumstances. And I should say that professionals and trust companies will always require a fee agreement to be paid. They do not work for free, but often there are sort of minimum thresholds in sort of assets that they will require. So sometimes there's a cost benefit analysis that needs to be undertaken to see if it's worth it or not. Okay, so just turning to foreign appointments, this really comes up very regularly. I think the world is getting to be a much smaller place. So individuals have family members or friends or trusted individuals who are all over the world, and people are moving. So firstly, I just want to clear up a misconception. There is no preclusion from appointing anyone who's foreign. So you can appoint whoever you want to be your executor, your trustee, your attorney. That is fine. But then there's a big but. It can cause a lot of complications, additional costs, delays in administration. So we always walk through the sort of pros and cons with our clients to make sure that they know what they're getting into, basically. One thing we should also say is that I know we are sort of Canada and we're one country, but every province, territory, they're all different jurisdictions. So just because we prepare a power of attorney, for example, in BC, doesn't necessarily mean that it will be recognized in Nova Scotia or even Alberta for that matter. So the documentation is very jurisdictionally specific. Obviously within Canada, there are there is some cooperation, which is great. But really, when we're talking about foreign appointments, we're talking about those outside of Canada. So in terms of options, obviously from our perspective, the best option is to appoint someone in BC. If that's not possible, the rest of Canada is fine. Obviously, just administratively, it can get a little bit burdensome, but from a tax perspective and a disclosure perspective, there's not too much of an issue. So one thing we do recommend is that if there is going to be a foreign appointment, that we at least have multiple layers so that those individuals have an out if they need to resign or renounce, for example. And sometimes we do put in place exclusionary wording. So for example, I have a client at the moment and she has 2 adult daughters, both of whom live in the USA. Not a great choice. We'll see in a minute why they're not great choices. So we put in some wording to say that if either of them are tax resident in Canada at the time of their appointment, then that's fine. They can take those up. But if they are tax resident outside of Canada, then essentially their appointments fail and it will drop down to the next layer. Okay, so there are a few complications of appointing non-BC executors, trustees, and attorneys that I just wanted to run through. So practically speaking, I've touched on this, but sometimes we do need sort of ID to be verified in person or wet ink signatures on the documents. So that just creates a little bit of an issue with trying to sort of coordinate that with the banks or notaries abroad. And my understanding is that US resident executors are not generally allowed under US law to deal with certain Canadian investments. Don't ask me about that because I don't know anything about that and I can't advise on it, but that's just what I've been told on a practical level. But I do understand that there are often internal policies at the financial institutions that prevent estate accounts, for example, being opened if the executor is US tax resident. A bond may need to be required and paid in certain circumstances, particularly in the probate process, when there are minor or vulnerable beneficiaries involved. The bond might also need to be requested at the if a beneficiary requests it. But the example there is a pretty recent example where it's a really sad situation. There's an intestacy, a young couple with a minor child. The husband went to Mexico and unfortunately didn't come back. There was no will in place. There were significant assets. So his minor child is due after the prescribed amount and everything has been calculated about $1.6 million. So that is the amount that the bond is calculated on. And you can see on the screen, the premium was about $7,600. So they're not small amounts. And that's, again, an example of sort of where do those funds come from if there are not sufficient sort of liquid assets in the estate. Someone needs to pay for that. There may also and generally will be tax or disclosure consequences. And I do have this discussion a lot with clients. Well, can I appoint 3 people who are US and 1 person who's Canadian? Can I get around it? So it's probably no. So the CRA's view is that if the sole or a majority of the executors, trustees, or attorneys are tax resident outside of Canada, and this is particularly important when the individual lives in the US, that they consider the estate or trust, etc., to be non-resident of Canada. So the test is where's the central management and control. So this is a little bit of a gray area. We have had cases where estates have gone through where the executor, perhaps one is in Canada, one is in the US, but the Canadian executor does 95% of the work. But we can't guarantee that the CRA won't take issue with it. So it's always important that we always have sort of a qualified accountant on board when we're doing this. And one other sort of additional consideration for US tax residents is that often they need to disclose the Canadian assets to the IRS, which scares a lot of people, understandably. And also there's additional filings that need to be undertaken on the US side as well. Okay, so just very briefly, I just wanted to go over the different types of appointments. So sole appointment is really straightforward. You appoint one person into any of these roles. If there is no one else appointed, obviously there could be a potential failure. Hopefully for estates and trusts, there are mechanisms in place, whether that's in the document itself or in the statute to appoint someone else. But for the power of attorney, for example, if you only appoint one person, they can't act, the power of attorney fails. And the only way you can have someone else appointed is to go to court if the donor has already lost capacity. So we do always recommend multiple layers, and that's where the alternates come in. So we say at minimum 2, 3 is great. And it is also a possibility to appoint multiple people on the same level. So in that regard, there are 2 different types of multiple appointments. There's something called together, and there's something called together and separately, also called jointly and severally. So the pros of having an appointment together means that everyone who's acting must unanimously make the decision, sign off on everything. It makes clients generally feel more comfortable that it's likely their wishes will be followed, but it's really inflexible because if something happens to one of those individuals, the whole appointment fails. So if you have one layer and you appointed your 3 children, for example, and one of the children die, the other 2 cannot continue to act. The whole power of attorney fails in that instance. So what we generally recommend is appointing together and separately, so that in the same scenario would allow all 3 of the children to be appointed on the same level. If one couldn't act for any reason, for example, if they had died or became incapacitated, or just had a really busy life and couldn't deal with the appointment, then the others could continue to act, for example. The pitfall with this is that you could have that sort of rogue child who goes off and does things that the siblings don't agree with, but that's sort of the pros and cons that need to be weighed when making those decisions. Okay, we still have 8 minutes, so hopefully I've still got you here. Are there any questions?
Yeah.
Or Felicia, you?
Yeah, I'll come back to you. Well, first of all, thank you to Lisa. And yeah, let's take some questions. I have some online, but maybe we'll start off with an in-person question first. So we'll just, if you keep your hand up, and we'll just kind of hand your, well, not for the whole time. That's okay. We'll get you here in front. We'll start at the back here. Yeah. Oh, I think that's Jacqueline. Yeah.
For a situation where someone has created their will at assume equal for their 3 children, they had capacity when they made their will, and they've now since lost capacity to make a new one. But one of the beneficiaries is a disabled, also no capacity adult child. So that person is going to inherit significant wealth, but they don't have the capacity to make a will of their own or appoint anything. Where can you start? Is there any place to start?
Yeah, no, that does happen. So I guess 2 parts. So once the person who makes the will becomes incapacitated, there's nothing we can do. So that will flow, or at least 1/3 or whatever the breakdown is, will flow to that disabled child. There are provisions for a trust, a special sort of disability or Henson trust to be created for that child after they receive the inheritance. That's done through the ministry, the government agency. We would help to facilitate the creation of the trust. And I think the time period is about 3 months where you have to do that within. There are certain circumstances where you can get an extension, but there are ways to sort of deal with that after the fact.
Okay, thank you. And I'm going to start with a question online here from Cheyenne. Can a named executor delegate some of the responsibilities of administrating the estate to a professional executor trustee and then just oversee things? How does that work?
Yeah, no, that is also a good question. So the appointments are very personal, and usually at the back of a will or a trust document, there will be powers given to the executor to be able to do certain things. Generally speaking, delegation will be one of those powers. But there are a number of powers that cannot be delegated.
And we have one question here.
Thank you very much. The first question is, can you change an executor via an addendum to a will, or must a codicil to the will?
Yeah, so yes. So the will can be changed by a codicil, which is like a formal amendment. It still needs to be a legal document. It's witnessed in the same way. So an executor change is one of those sort of simple amendments that we do all the time by codicil. But we hesitate when doing or preparing codicils because they also become a public document. So a lot of individuals don't realize that the will itself becomes essentially a public document. It's searchable. Someone could sort of pay and download it. And then the codicil is attached to that. So if you start making changes to gift amounts or beneficiaries or those sorts of things, generally we suggest putting a new will in place so that someone can sort of track the changes that you've made.
Okay, thank you. And then the other one is just confirming my understanding. Executor quits 3 months into the role. It's then upon the beneficiaries, you're saying, to go to the courts to get an administrator then at that point, because they.
It depends what's in the will. So generally speaking, once you've the term is intermeddled, or you started acting, you can't stop. So if someone dies, for example, obviously there will be a mechanism to put someone else in place. But when you start, you really do need to finish the role, basically. But we generally recommend, and a lot of firms do, that there are multiple layers to prevent that. But if you get to an instance where there's no one else who can act, then it would go to the waterfall of individuals who would have to potentially get a supplemental grant in the name of the new administrator.
Okay, there's a bunch more questions online here, very active chat over here. Second question online, how much work is it for a trustee who is named on a minor's life insurance beneficiary designation to do what they need to do? A lot of newer immigrants don't have families locally and end up naming foreign trustees, also given their estates are not as large enough to involve a professional trustee.
Right, okay. So, I mean, there is a lot of work involved in trust in general. So if it's just restricted to the life insurance proceeds, obviously they have a duty to make sure that those are invested and are sort of maintained for the benefit of the child. The foreign trustee aspect is more of a tax question, but I can foresee that will cause some complications.
Okay, thank you. In-person question, Lloyd, and then we'll.
Yes, maybe you could comment on how important, if you're going to renounce the being an executor, how fast you have to do it. Like in other words, you sort of alluded to it a moment ago. That's very important. And the other, are you familiar with the new and the securities industry? We have this thing called a trusted person that you can contact. It's creating incredible chaos. Most people think they've appointed a power of attorney. Have you bumped into that yet?
So I'll address your second question first. I've heard it's chaos. I haven't run into it yet, thankfully. For the renunciation part, you do need to do it quite quickly. So it has to be done at the outset. As I mentioned just a minute ago, if you've intermeddled, if you started to do things and sort of put yourself out as acting as the executor of the estate, then you have to continue to act. You can't just sort of do a little bit and then remove yourself from the process. So it's a formal sort of document that needs to be completed to confirm that you've renounced.
Okay.
Oh, sorry, no, no. I've only heard that it's chaos, but I have not bumped into that yet.
Okay, question online here. What is a bond, actually?
Oh, so a bond is an amount of money that needs to be paid in to basically secure the minor or vulnerable beneficiary's interest in case the executor runs or they can't get the assets, is to protect their inheritance, basically.
Okay, I think we have another question, Mehul.
First, just a comment on the online question, I think about the insurance proceeds going to a trust and a foreign and all that kind of stuff. They could consider a trust company in that case, appointing a trust company could help just for that person. But my question was, I stepped out for a second, so maybe you talked about it, but could you maybe elaborate or talk about a little bit about committateship and how that could be helpful in cases where, you know, a POA or someone was not appointed and an individual, like in Jackman's?
Yeah, sure. That's a really great point. I'm sorry that I didn't touch on it. So the Section 9 power of attorney is used when there's sort of full capacity. The Section 7 representation agreement is used when there's sort of diminished capacity, but there's still a level of capacity that needs to be there. If there's absolutely no capacity, then that's when the comiteeship would come into play. And that's essentially a court process to appoint someone to act on someone's behalf.
We also have more online questions from Phil. In a situation of together and separately, if there is a tie, for example, two people named as trustees who don't agree on a decision, how do you break the tie?
Yeah, no, that's a good, these are all great questions. So if there's more than, so if there's an odd number, we usually include a majority clause. If there's an even number, then we will often include sort of a casting vote.
Okay. Seems very straightforward. No.
I wish it was.
Okay, one more online question, follow-up question actually on the foreign trustee on life insurance designation. If it is expected that the minor beneficiaries won't continue to live in Canada, if their parents, the insured, were to die, what's the best way to make the designations on the will, life insurance investments?
So I think it could be treated like any other trust. I think you can only plan for what you know at that moment. So probably having, as you said at the back, sort of a trust company or someone in Canada to deal with the trust when that person passes away. If the minor beneficiaries end up moving out of province or out of country, usually, definitely if there's a sort of trust company involved, they will have powers to release their powers essentially, or pay it out to the foreign jurisdiction if it makes the most sense for the minor beneficiary. So we don't have that cross jurisdictional problem.
Thank you. Any other yeah, sorry, the light here, I can't quite see it.
Thank you. I'm going to try and select two quick ones in here. Is there a sweet spot for the valuation size in which returns can cover the fees on a trust without eroding the value? And did I understand you correctly that in a trust deed, in the absence of special wording, there's a limit on how much the trustee can distribute on special disbursements?
So the first part of your question, sorry, remind me of what the first question was. So, oh, sorry, no. So it depends. To create a trust, I mean, there are lots of sort of legal and tax changes that have happened over the last few years. So trusts are not as sort of enticing as they used to be. But for the annual, I mean, generally speaking, I'd say 1 to 2 million is probably where you want to start. But there's a huge variety in sort of setup costs, accountancy fees. So it really depends on sort of what you're looking to achieve. We have put trusts in place for much less, but it depends on sort of what the ultimate goal is. Tax should not be the only driver for sort of these sorts of structures. So, and remind me of your second question. Oh, that was in relation to the power of attorney. Yeah, so those are very heavily regulated, and it's very prescribed in the Power of Attorney Act, but you can expand those powers in the actual power of attorney document. Yeah, what I mentioned was not to do with the trust. Yeah.
Okay, we'll take one more question if there's any questions. If not, then thank you so much, Alyssa,
Thanks,
for
everyone.
being here. Thank you. Yeah. And so I have to apologize to all of you because I think that in my eagerness, this session was supposed to be started at 1:15 and not 1 o'clock as I thought. So apologize to all of you online who didn't catch the first part. Hopefully you can refer to the slides and the recording afterwards. So in lieu of that, I'm supposed to be making some sponsor announcements at 1 o'clock, which I'll do now. So again, we want to thank our sponsors, some of our community sponsors here. I'll just mention them by name. We have the Paradox Hotel, which is hosting us today, and then My Family Office, and also Clark's Audio Video is doing a great job, helping us do the video and also all the online audio video components. We also have Indochino, which we talked about. And then also West Coast Actuaries are here as well. So thank you so much for your sponsorship, without whom it would not be possible, again, for us to host it here today. And so our next session, actually, before I send you on you get an early break, but before that, there is a contest coming. So let me announce how to do that. So this contest is for Apple AirPods Pro, and it's sponsored by Home Equity Bank. And so this is the last contest of the day, and this is open to both in-person and virtual attendees. So from now until the end of the break, which is at 2:30, if you could look for Tim Whitaker on your attendees list, and he's from Home Equity Bank, and send him a message just with your name, email, and phone number for a chance to win a pair of Apple AirPods Pro. The contest will close at 2:30 at the end of the break. And so one lucky winner will be selected. And so also just a reminder that the Indochino suit giveaway is ending at 3 p.m. If you haven't done so already, please take a chance to visit their display. I think it's right outside these doors here for a chance to draw to win a custom tailored suit. So with that, we're gonna finish a little bit early. Give you a bit of a longer break, and we'll resume here at 2:30. So please mingle, have some more coffee, more snacks, and please check out our sponsors, and we'll see you back here at 2:30. Thank you.